Penguin Random House, along with five other publishers, a group of celebrated authors, parents, students, and the Authors Guild have decided to challenge Florida's HB 1069, which is the bill that represents a wide range of regulations that affect school and classroom libraries. 1069 is causing tremendous turmoil and havoc across the state of Florida. We've heard from countless students, teachers, librarians, parents, and other concerned individuals that have told us about the devastating effects on their schools and their lives. It's a law that has caused thousands of books to be removed from library shelves. These are books that are longstanding classics as well as what we'd call modern classics. So, some of the books that we've pointed to in our lawsuit include things like Slaughterhouse-Five, that's been around for, half a century.
All right. And you mentioned you've heard from so many people. Do you have any specific examples of the impacts that this law has played out in schools?
Yes. In addition to the removal of books en masse, we've actually heard from educators that have left the profession entirely in Florida because they just can't do their jobs. There's no purpose to running a library if there's no books, right? I mean, that's the heart of the library. So it's a really, really intense, charged climate down there. Librarians feel like there's a target on their backs. Personally, the level of rhetoric that's been um, directed at them is terrifying. I mean, we're talking about sometimes threats to their lives, not just their livelihoods. So it's a really a devastating situation going on right now.
Right. And you mentioned that the House Bill 1069 has broad and vague language. How concerned are you about the potential of misuse and overreach by local communities? And do you think there should be any safeguards? And if so, what safeguards should be implemented?
We've been really careful in our complaint and in our advocacy to identify what exactly our problems are with 1069. We are not challenging the provision that was pre-existing but continues on in the law that bans or forbids obscene material. So when people say pornography, what they really mean is obscene material. Florida has already had laws that prohibited obscene material in schools. There were already mechanisms to address that. What 1069 does is create an end around obscenity and bans books for other reasons. So uh, we don't have any issue with, for example, parents asserting interest in what their students read, what their kids read, and libraries working with them to meet them where they're at. What this law does is remove all parental rights by focusing on individuals in a community that can file a challenge form and get the book removed for everybody. So it's not really about pornography. To us, that's a red herring because if pornography includes Anna Karenina, Slaughterhouse-Five, the works of Faulkner, Toni Morrison, our author, co-plaintiffs, that's John Green, Angie Thomas, Jodi Picoult, Laurie Halse Anderson. I mean, you're not going to go very far convincing most Americans that those books are pornographic.
And Penguin Random House is a major publisher. Have you heard from any of your authors about these things going on in Florida and across the country?
Absolutely. The alarm has been sounded. We've been hearing about this for quite a long time. It speaks to how difficult it is to build these challenges and file these First Amendment cases. We've had our eye on Florida since the beginning, really. But we thought it was important to build a coalition. We wanted to make sure that we were working with people on the ground. We have, local. This is not a project of a bunch of people in New York deciding what a bunch of people in Florida should be reading. We have student co-plaintiffs in this case that have their own say in what they want to read, or at least deserve a say in what they want to read, as well as their parents. So really what we're trying to do is bring everyone together. We've heard from authors across the country. Sure, a lot of it's coming from Florida, but this is a nationwide phenomenon. And they're isolated. Authors are solitary workers. They don't come in and sit at a desk like I do. So they are really on their own, and they've been dealing with this far longer individually than most people realize. So it's not tenable to ask authors to protect themselves against things that are so much larger than any of us. So we had to put together a coalition so that we could have their backs.
Some argue that parents should have more control over what their children read in schools. How do you feel you can balance parental rights with the need to provide a diverse range of perspectives through these books?
We are laser-like focused on library and classroom collections for a reason. That is voluntary reading. Those are books that students of all ages, I'm not talking just children here, this is 17 and 18-year-olds included in this, that they want to read in their free time. That is like the most time-honored American tradition is the right to free thought. And so we've never had this issue before where one set of people is overriding everyone else's prerogatives. Sure, it's come up in the past. I mean, we can point to things, it's been about 90 years since the United States tried to block importation of Ulysses. That book is still on ban lists now. I mean, that book is still being challenged 90 years later. We have examples, throughout history, but I'd say over the last several decades, no, this has not been something that most people thought was a problem. And when you look at the list of books that are getting banned, it's books that have been around since the 1970s, earlier even, like I said, Ulysses. So, I've spoken to librarians across the country, and they all say, without fail, I've never met one that didn't say the same thing, which is if a parent comes to me and says, my kid is not ready for this book, they work with that parent. This has become a one size fits all, lowest common denominator. If one person in the community finds this book offensive on behalf of their child, then nobody gets it. So that's just, to me, is not parental rights. That is the state putting its thumb on the scale and deciding which perspectives and viewpoints are available to its young people.
Right. And what message do you hope this lawsuit sends to legislators, and the broader public about the role of books and literature in society?
I think that we have to get to a place where people accept that we can agree to disagree. As a general interest trade publisher, Penguin Random House publishes everybody. I mean, I was doing an exercise the other day where we took all of our publisher co-plaintiffs. I think that we have like something like 7 of the 9 Supreme Court justices who have written books. They've written books for all of us, right? So we publish the widest range of ideas. We don't believe that every book is for every person, or if it is, not at every point in their life. Like books get matched to people in a very idiosyncratic, individualized way. And we're not arguing that our books must be encountered by anyone. We're just arguing for a fair shake at it. I think that that is transpartisan. There's no ideology inherent in what we publish. It's everything. And so as a young person myself growing up, I read books that I disagreed with. Sometimes they changed my mind. Sometimes I felt like solid in what I already believed. It's not scary to read things that you disagree with. And so it's a really dangerous idea to let the government decide which books people can encounter. And I know that there's arguments that, well, it's not illegal to own a copy of the book. Sure, it's not. But where do young people, where do people, ages 6 to 18 find books? It's through libraries. That's where they're getting it. And for many people, they don't have the resources, they don't have transportation. They don't have the funds to be able to go acquire every book for themselves that the library refuses to stock.
All right. And moving on to the legal aspect of it, I saw that there was legal action in Iowa regarding this. Could you tell me where you guys are at with that?
The Iowa case, in many ways, served as a template for what we're doing here in Florida. We're really encouraged there. Again, 5 other publishers. That's Hachette Book Group, Macmillan Publishers, Simon and Schuster, HarperCollins, and Source Books. We're all in on this together. So I think that sends a message that the book industry is not going to take this lying down, and that we are prepared to fight and fight wherever we need to be. The fact is, in Iowa, the law is really similar to the Florida law. It in many ways is patterned after it. The core defense that has been argued or asserted by the state of Iowa is likely to be the same one here, which is that the government, when it creates a library, has total dominion over the messages in it. It's called the government speech doctrine. And the idea is that there's no First Amendment in libraries. It's a completely contrary to 200 years of American history and experience. And it's a really dangerous notion. That argument was rejected in Iowa by the Eighth Circuit Court of Appeals. That's a really good sign for us. And we expect that it'll be rejected in this case if it is raised. So Iowa was an important kind of, like I said, a template. We've learned a lot by litigating there. We've applied a lot of the takeaways there to this case to make it strong, streamlined, and ultimately best positioned to deliver justice to Floridians.
And with that being said, how confident are you about this legal case in Florida?
I'm really confident about it. I think it's as strong a case as you could make. Ultimately, we put these things out there not because we're certain that we'll win, but because we believe it's necessary to fight. We want to put the other states on notice that Iowa is not a one-off. We're prepared to defend the right to read and the right to speak. That's the author's right in this case, wherever it's being imperiled, and it's important to fight. And so I do expect that we'll win in this case, but it's necessary no matter what the outcome is.
All right, looking forward, what's the timeline for this case?
Well, gee, that is a really complicated question because that invokes a lot of legal machinations.
Maybe like a dumbed down version for listeners. What's next?
What's next is the court will have to decide. This will go to a federal court. This is in federal court now. The judge will decide how quickly he or she needs to move on this. It is styled in a way that is, like I said, it's very streamlined, and I think certainly does not require any discovery. Like, we don't need to be doing any depositions or further research. The facts are in front of the judge. The judge can move as quickly as he or she is able to. So, this is something that we've positioned to be able to be resolved really expediently. So my hope is that we're talking weeks, not months, or months, certainly not years. Ultimately, this case will take as long as the state of Florida decides it needs to take, because if we do get an injunction ultimately blocking a law like this, that's always subject to appeal. That would go to the 11th Circuit Court of Appeals, and then from there it could go to the U.S. Supreme Court. So there's a fast lane where the state of Florida decides to issue reasonable guidance to help districts understand what the Constitution protects, in which case, we don't have to have a lawsuit. Then the slow lane is that this goes on for years, and ultimately the Supreme Court has to decide. So I'm going to give you a range of a few months to a few years, and I couldn't tell you. I'm not a gambler, so I couldn't handicap what the over under is.
All right, and Dan, lastly, is there anything else you'd like to add that you feel we didn't cover?
I'm really grateful that we've been able to find people on the ground in Florida, in Iowa, and other places that put their trust in us as publishers. That includes the authors as well, to vindicate their rights as well as our own. We've never had this before. We've never had a group of publishers putting their name on complaints like this in the last, I think, 50, or maybe even goes back further, 70 years. And so it's, in some ways it's unprecedented. In some ways it is precedented. Just the precedents go really far back. We're not asking the court to do anything new or unusual. We're actually just asking the court to establish hundreds of years of precedent for freedom of speech and freedom to access information, and treat young people in Florida with respect, and allow them the ability to read freely, to decide for themselves what information is relevant to them.